Using geofencing to target unidentified suspects. It's a practice often used by law enforcement, and it allows officers to find people who were present within a specific area during a particular time.
The Fourth Circuit Court of Appeals recently upheld a previous decision to deny a motion to suppress evidence obtained from geofencing. However, the court decided to pass on addressing if geofence warrants are constitutional. And joining us for a closer look into this, our Chief Legal Analyst Khalif Rhodes. Khalif, this is kind of a new era, right? Because 20 years ago, we were talking about geofencing locations. How does that all work into whether you can get a warrant for it, your rights? Break it all down. Is it constitutional? Is it not?
Julian, I'll try to break it down, but even in my 4-hour law school class, that wouldn't be enough time. You probably need the whole semester to deal with this topic. I mean, you had this case that went to the district court. It went to the Court of Appeals, a 3-panel. Then it went to an en banc panel, which is all of the judges heard it. So 15 judges heard this case on oral argument, and none of them could agree on anything. 14 of the judges came together and said, we will agree to uphold the 3-panel decision. One judge dissented, but they had no majority opinion. There were 7 concurring opinions, and everyone was making crisscross arguments. So your question of asking me to clear it up, it's going to be hard because you had 14 to 15 folks that couldn't even say the same thing in a 126-page document. But what I will tell you is a couple of things. These things, I see them all the time with my homicide cases where they will say, look, your client was in this location. We asked Google for the data, and they provided, and his phone was pinging off the tower, his geolocation tracked. But this allowed me to do a deeper dive to figure out, well, what's even happening? They're saying that Google can even show what floor you are in the building. That's how deep and specific it is. But the problem with these type of searches is not the person they're looking for, and that was what the dissenting judge talked about. It's really that it's violating the rights of the other folks that really have nothing to do with this case. And so they asked for a perimeter, a diameter of 3 football fields. 3 football fields, and guess what they got back? 19 different individuals' information. It was anonymously given to them. So then they asked to narrow that information down. The officer narrowed that information down by asking for 3 additional hours before the incident happened, narrowed it down to 9 people. Took that information and said, well, let me get those 9 people's phones and don't just make it for that geographical area of 300 yards. Let me get wherever they were, anywhere. The court talked about that even in some of the concurring opinions, saying, well, you're allowing this officer to come back and ask you for information for folks that have nothing to do with this case. You're asking for information that was at a time frame that had nothing to do with the robbery incident. And you're asking for information that had nothing to do with the location. Most of the time, those 3 triggers would be rationales with why he would have to come and reapply every time for getting a new warrant. But this all happened on the same warrant, and they're saying those other folks, those 19 people that originally were implemented, they should have never had their information distributed to the law enforcement officer without getting a specific warrant looking for their information. I know a lot to unpack, but for sure, this was a good read, but complicated at its best.
So the core of this argument that's confusing, maybe not confusing, but at least dividing so many different legal experts here is it's the right to privacy. Is that right? Specifically for, again, say those 19 people that would have never been suspects in the first place had geofencing warrant not been fulfilled.
And not just that, did you recognize that when I clicked yes for sharing my location on my phone, that would subject me to being given a warrantless search? And that's what the court talked about, it probably for about 50 pages, that I didn't recognize that when I hit enter on that button to allow my search function to work, which we need on our phone, because if I want to find restaurants that are close to me, you got to turn on location, precise location to show me. And so they're not just asking Apple, they're not just asking Android and Samsung, they're asking Google because they touch most of the apps that people are using. And what they're recognizing, that's how they get the most data sent back to them. But I mean, it was clearly an infringement on those 19 folks that had nothing to do with these cases of constitutional rights. And Sotomayor, the Supreme Court Justice, she talked about this in another case. She said, look, our Fourth Amendment rules and our precedent isn't keeping up with our technology and how fast it's evolving. The rules that we used in the past for dealing with a paper warrant or for someone's physical location is not the same as for their phone, which is now a part of your body. You're not leaving the house without your phone. You're not going on a trip without your phone. And so that should be extended to there, and it seems like it isn't. And that's some of the problems that they talked about here.
Khalif, do you see this eventually getting to the Supreme Court? I know people were upset that they didn't take this issue and rule on the constitutionality of it. What would need to happen for it to get to the Supreme Court? Because it's not just that. You think about security cameras. There's the expectation of privacy. Once you leave home, now you have cameras on you, have your phone tracks location. Could we see this get to the Supreme Court? What would be the path to get there?
I would think that this is something that would be right for the Supreme Court to look at, but I would even, if you're talking about your analogy with cameras, I think your expectation of privacy is limited. It's diminished because you're outside in the public space. But my phone, my private phone that I purchased, that my information is on there, I would make it, if we're taking it from an electronic device and putting it to old school piece of paper,
right.
I would have an expectation of privacy to my notes that I draft and I write, and then an officer would have to physically go and say, you know what, we need a warrant for his diary, for his journal. Give me a warrant so I can see what's in there, force him to turn it over to me. Well, in this case, that's not happening. They got 19 different journals from folks that they didn't get 19 different warrants from. That's the problem. There were people in churches, in hotels, at their house, not having anything to do with this crime, that because they were inside that circle that was 3 football fields, their data got turned over when it shouldn't have been. And that's the types of things that are being contemplated with these decisions. So to your immediate question, yes, I think the Supreme Court would love to address this, but you would want to have had this court address the issue first so that the Supreme Court could touch it. And right now, they skipped on that and just sent it back and say we affirm without underlining and addressing the main question.
And we're still looking at one case in this conversation. I believe it was 2020. There was more than 11,000 geofencing warrants. So this has the implication to reach several thousand people very quickly.
Every homicide case that I've ever touched, every drug trafficking case that I ever do has some geofencing data submitted to me where I will be able to say, well, hey, I can use it for my good or I can use it for my bad. If you're saying you guys pulled the phones and my client did not ping there, well, why are we here? And then they may say, well, he turned his phone off or he turned his location tracking off. And that may be the argument that they will make. But oftentimes it will be, hey, we have him sitting right there. The incident happened at this cross street. His phone didn't just ping in the 300-meter range. It was at the step of there, and they can put it to the precise location of where they were.
Khalif, going back to something that you brought up when you were answering Savannah's question, should people be more aware of the fact that when they opt in for location, when they opt into these different search things on their phone, that you're kind of giving up your expectation of privacy because you're letting the government know, hey, I'm right here?
Well, first they would need to know that Google has these agreements with the government, right? That there's a standing agreement that if they access through the process that they can get this information anonymously and they can get it and then they can go out and track down and figure out how to actually figure out who that person was. They found out this person was in the location with the robbery because when they were looking at surveillance footage, they saw a cell phone in their hand. And that was like, okay, we need to get the geo-tracking location to see who they were talking to while this robbery was going on. But what I would say is if you're a person that's thinking about committing a crime, yeah, you probably want to know about it then, and you maybe not want to opt in to the location sharing, because guess what? It's not just being shared with Google, it's being shared with everybody.
All right, Chief Legal Analyst Khalif Rhodes, thank you so much for giving your perspective on this. Of course, it's something we will definitely continue to be talking about as this moves through the courts.